Good afternoon. My name is Nicholas Chung, and I'm a chartered professional accountant. And it's my absolute pleasure to be able to speak today about estate planning. The Chartered Professional Accountants of Canada is pleased to present this topic in a series of presentations designed to help Canadians improve their financial literacy. We have about an hour today with some time at the end for Q&As. You should have a copy of my presentation in front of you, so please feel free to take notes as we go along. And as this is an interactive session, please ask questions at any time. Your questions will help make this session a better one, so please don't hesitate to ask. So let me just take the time to go over some of the things that we'll be discussing in the next hour. We'll be talking about what is financial literacy, what exactly is estate planning and why is it so needed, and some estate planning tools that you should consider for your estate plan. So what exactly is financial literacy? Financial literacy is having the knowledge, skills, and confidence to be able to make responsible financial decisions. And knowledge refers to an understanding of personal and broader financial matters. Skills refers to the ability to apply that knowledge to everyday life. And confidence means having that self-assurance to make important life decisions. So responsible financial decisions refers to the ability of individuals to use that knowledge, skills, and confidence that they have gained to make choices that are appropriate to their own particular circumstances. So I hope that by today, at the end of today's session, that you will have improved your financial literacy. The Chartered Professional Accountants of Canada has commissioned research about Canada's level of financial literacy. And quite frankly, the results were a bit of a wake-up call. Canadians certainly need to improve their financial literacy skills. In particular, they need to save more, spend less, and reduce their debt. And these results were very much consistent with the results and recommendations that came from the Federal Task Force on Financial Literacy. Most Canadians believe that responsible money management is an important life skill. And estate planning is one of those important money management skills to learn. As CPAs, we know about money. Advising individuals and businesses about their money is what we do. CPA Canada and our members across the country are uniquely positioned to help with financial literacy and are taking a proactive role in delivering this particular program. So what exactly is estate planning? It's the process of creating a plan to distribute your assets, either during your life or after your death, to take care of the people and things that are important to you. And I think it's important to note that it includes how to prepare for the possibility that you may not be able to make a decision at some point in your life, such as a severe injury or medical condition. So why would we want to do something about estate planning? Well, one of the reasons is to help ensure that your dependents and your beneficiaries have income and assets for their ongoing needs. The loss of income means that some planning is needed to figure out how that income can be replaced. One objective may be is that you wish your dependents to maintain a normal spending pattern without substantially altering their lifestyle, and that really means that you have to plan for it. Another reason is to avoid and minimize family disputes. So by planning ahead and anticipating issues and discussing these issues with your family members, you might be able to reduce the likelihood that some of these disputes may crop up. Another reason is to convey your wishes about how you wish your affairs to be administered, including guardians for your children. By not conveying your wishes, others, such as the government, courts, and even others that you may not necessarily trust, may be able to make decisions that you would not necessarily agree with. Also, another reason is to minimize costs and taxes. The normal desire is to pass as much property as we can to our heirs. And minimizing taxes can be an important consideration in this regard. And lastly, and maybe even mostly importantly, is that to establish peace of mind. There is some satisfaction that can be had from putting one's affairs in order. Death is inevitable, And by realizing that planning is the most efficient way to provide for one's loved ones and friends is an important thing to realize. So let's talk about some of the steps involved with the estate planning process. Well, number one is to establish objectives. Most objectives center on preserving and directing the distribution of assets, while reducing any tax liabilities, ensuring that funds are available for ongoing needs. Step two is to determine your current financial status. You need to identify all the assets that you have and the form of ownership, including whether it's solely owned, might be jointly owned, whether you own shares in businesses. These are all very relevant to determining all your financial picture. This should also include life insurance proceeds and potential inheritances. Step three is to develop a plan. And you may need to consult a professional, particularly a lawyer, to help with the drafting of legal documents. You also need to consider various strategies and tools to best carry out your plan. And some of those tools and strategies we'll be discussing later on today. You also need to consider who you'd like to ask to carry out your wishes on your behalf. And this is a particularly important consideration. It not only has to be someone who you trust, but also has the time to carry out your wishes. The next step is to implement a plan. This certainly might include finding a lawyer, drafting legal documents, moving and transferring of assets, and buying insurance. And lastly, but certainly not least, is to update a plan. We certainly recommend in reviewing your estate plan every 3 to 5 years, or when a major life event may occur, such as marriage, divorce, birth of a child, receipt of inheritance, or when a significant health issue occurs. Here are some of the tools that we're going to consider in today's session. Now, certainly this list is not all-inclusive, but see, these are some of the more commonly used tools that are used in estate planning. So we'll be talking today about powers of attorney, wills, joint accounts, gifting, and trusts. Powers of attorney. What exactly is a power of attorney? A power of attorney can be a particularly useful document, but it is also a very powerful one because it can allow another individual to act in your name, just as if you were making those decisions yourself. Each province has its own laws that govern powers of attorney, so it's best to consult your provincial Attorney General's office for more information. In either case, the power of attorney becomes valid when the grantor, which is the individual granting the power, dies. A power of attorney cannot be used to bequeath property upon the death of the donor. So when a person dies, the executor, which is also called a personal representative, is appointed in the person's last will and testament and takes control of the deceased person's property and distributes it according to the wishes in the will. When can a power of attorney come in handy? It can come in handy in a health crisis, when you are unable to manage your own affairs or handle your business. A power of attorney can allow someone to step into your place to manage some of these affairs on your behalf, such as paying bills or making key life decisions. Even if you're going away on an extended vacation or trip, it can be useful to have someone, to appoint someone in your place with a power of attorney. A power of attorney can be effective for whenever you wish. It can be made for a specific period of time, such as whenever you're out of the country, or it could be effective immediately. Or in another case, it can be made effective upon an event in the future, such as when you become incapacitated. A general power of attorney is one that gives the attorney the authority to do anything that the donor could do him or herself. However, you can also have a specific power of attorney for a particular situation, such as handling a real estate transaction. Now, generally, there are two different types of powers of attorney. One is for property, which generally covers things like what's in your bank account, your house, your investments. And the other one is for healthcare. The one for healthcare is also known as a living will. And it can provide instructions to the substitute decision maker. It can talk about your wishes about perhaps not using extreme measures to prolong your life when there's little chance for recovery. Or it could also say that every effort must be made to prolong your life. While some provinces may not recognize instructions contained in the living will, it does provide useful guidance for the substitute decision maker and for family members. So before we go on to talk about a will, let's talk about what happens when you don't have a will and you happen to pass away. This is called dying intestate. And without a will, the government will be able to distribute your assets according to a preset formula. So in other words, you really have no say on how your assets will be distributed. Also, you won't be able to influence as to who might be able to look after your own dependents. It may take some time for the court to appoint an executor, so thereby freezing your assets. So it may take some time before your dependents get access to those assets. Assets that are distributed could be taxed without a proper strategy. Generally, all assets are liquidated, which may or not be what you had particularly intended. You might have intended for someone to have that particular investment. But normally in these type of situations, the executor may actually liquidate your entire investment. Division of assets between spouse and children vary between province. And even the definition of spouse varies and can have an impact on asset distribution. Generally, if there are no children, the spouses get everything. But if you do have kids, they will get a portion. It is important to have a will no matter what life stage you are in, especially after major life events, such as getting married or having children. According to a poll conducted for BMO Harris Private Banking, barely half of Canadians have a will, but 60% of those individuals say that they plan on getting one drafted. Always advisable to have a lawyer to draw up your will. Make sure that you get someone to witness it and that someone knows where to find it. At the same time, you should also consider having your powers of attorney for your property and health needs drawn up as well if you have not already done so. Finally, update your will at least every 5 years or after every significant life event. It can also be a good idea to tell your family members about your plans. You don't need to mention numbers if you don't want to, but by telling them your plans, it certainly reduces the likelihood that they may have any questions and disputes later on. The second important step is to select an executor. The executor is the person responsible for executing your wishes according to the will. This is not an honorary position, and it can be extremely time-consuming. So be sure to select a capable individual and get their agreement in advance. At this particular time, I'd like to ask any of you if you have any questions about the material that we've covered so far. One thing that I think it's important to point out is that once you pass away, you're deemed to dispose of all capital property at fair market value, unless you transfer these assets to your spouse. So what exactly is capital property? Well, this can include cottages, investments in stocks, bonds, and real estate. So if you acquired this capital property a long time ago, and let's say, call it a cottage, let's say, and you acquired it many years ago for $100,000, but now it's worth $300,000. Well, whenever you pass away, that accrued gain, which is called a capital gain, will be taxed. So your state needs to have enough funds to be able to provide for those taxes. As part of estate planning and drawing up a will, it makes sense to take all these particular cash needs and expenses into consideration to ensure that enough funds are available to provide for these outlays. So let me take a little bit of time to explain what probate and probate taxes are. Probate is the process of establishing the validity of a will and the authority of an executor. Generally required when someone dies intestate. The estate includes real estate, assets held by banks, or government bonds. Now, probate taxes vary from province to province and are usually based on the net asset value of the estate. Quebec is the only province that does not charge probate taxes. Now, there are ways to reduce the assets that are subject to probate taxes, some of which will be discussed later on today. But those include joint accounts, life insurance, RSP, and trusts. Registering assets under multiple owners, otherwise called as joint ownership, is one of the simplest ways to transfer assets. In the case of joint tenancy with the right of survivorship, when one party dies, ownership is automatically transferred to the surviving party. So one of the benefits of joint ownership is that it's useful for avoiding probate taxes, but other tax and legal issues certainly can arise. You have to be comfortable with the other individual having access and control over these assets. And this cannot necessarily be used in the province of Quebec. Now, I have actually used this particular strategy with my grandmother. When my grandfather passed away, we established a joint account together. So it was just my grandmother and myself as joint account holders. So when she passed away, those assets were transferred to me, which I could then distribute according to her wishes, which were not necessarily contained in her will. But that just made it easier for her beneficiaries to access those assets very quickly. Now, gifting assets is one of the easiest ways to transfer assets. But there are some tricky things that you have to realize, because they can create tax liabilities when you do so. If the asset is a capital property, and we discussed this a few slides ago, the asset is deemed to be disposed of at fair market value. So if there's an accrued gain, it will trigger taxes that have to be paid. But if you're transferring money to adult children, this does not result in any taxes payable. However, one key thing to remember is that gifting money to minor children will trigger what we call attribution rules, which basically means that when you give money to a minor, or let's say to your children, the income that they derive from that asset is actually attributed back to you and actually has to go on your tax return. So some planning certainly is required. And also, make sure that you don't give away too much money. People are living longer these days, so it's imperative that you make sure that you have enough money for you to live on. Another useful tool is trusts. And what are trusts exactly? A trust is a legal entity that you can create to hold various types of assets. It can be created either when you're alive, which is called an inter vivos trust, or upon your death through your will, and that is called a testamentary trust. And each has particular tax benefits or disadvantages to that. Once you transfer your assets to the trust becomes their legal owner, and the trustee, which is someone that you appoint, becomes responsible for managing them. Part of the trustee's responsibility is to distribute the income and assets of the trust to the beneficiaries, designated by you in accordance with the terms of the trust. If you happen to have assets, perhaps above $150,000, you might want to consider having a trust, because there are particular tax advantages if you do so. But do remember, there is a lot of paperwork to consider. What are some of the benefits with having a trust? One of the benefits is that it ensures that assets are managed for the benefit of beneficiaries. So this certainly can be an important consideration if beneficiaries are minor children, as they will likely have no experience in managing their money. Another benefit is that you can control assets without actually owning them. Subject to the rules created for the trust, the person donating the assets, also known as the settlor, to the trust could still control the assets as if they still own them. But since the assets are held in trust for the beneficiaries, the settlor is no longer the legal owner of those particular assets. A trust can also shield assets from creditors. Because the trust is a separate legal entity, creditors cannot go after the assets in a trust. It can also reduce taxes. One of the most common goals of a trust is to ensure that wealth is transferred to one's heirs and beneficiaries in a tax-efficient manner. It can also create opportunities to split income with individuals with lower income. And it can also avoid probate taxes. A trust also lets you avoid the public process of probate. A will is subject to probate. This probate application must list all the assets of the deceased and certainly can be made available to any member of the public. With a trust, this is not the case. Many Canadians should consider having a life insurance policy, especially those with dependents. Now, this isn't meant to be a life insurance education session. So if you require additional information, you should consult a life insurance professional. But for the purpose of this session, I'd like to share with you two key messages about life insurance. One, the proceeds are paid out tax-free to your beneficiary or beneficiaries and avoid probate taxes. Secondly, life insurance proceeds are typically used for some or all of the following purposes. To help maintain the lifestyle of your dependents, for example, your wife, your children, and their home, lifestyle, or education, to pay funeral and related expenses, and to pay estate income taxes. Wow. So we've certainly covered a lot of information today. So I thought I'd just take this opportunity to recap some key ideas from this presentation. Draft your powers of attorney, maintain an up-to-date will, and remember that a good estate plan will help you to minimize or avoid taxes on your estate, including probate taxes. The key message I'd like to leave with you today is that you should take responsibility for your own estate plan, and in fact, for all of your financial planning. We've produced these sessions to create awareness about a number of particular topics, but it's important to you as the individual to take control and to research what is necessary to improve your financial literacy. Take the time to research this particular topic in more depth. And we've listed some recommended websites for you to take a look at here. However, it is always advisable to seek professional assistance before implementing a plan. As we've reached the closing of our presentation, I did want to thank you for your attendance today. On behalf of CPA Canada, I'm very pleased to have been able to present this presentation on estate planning to you. And I certainly hope that it has helped you to improve your financial literacy. Please take some time to fill out your evaluation and return it to me once you're done. And I'll open the floor to any questions that you might have. Please take a moment to read this particular slide, and if you have any questions, please feel free to ask me.